Hello, and welcome to Hospice Insights, the Law and Beyond, where we connect you to what matters in the ever-changing world of hospice and palliative care. A significant departure, unpacking what the new antitrust guidelines mean for healthcare. Wendy, we've been planning this podcast for a while now. This was big news when this came out, these new guidelines, which are in draft, but nonetheless, real significant. So were you surprised?
I was not surprised, primarily because we in the antitrust bar have been hearing about the proposed new guidelines coming down the pike for a while now. When DOJ and the Federal Trade Commission withdrew the 2010 version of the merger guidelines, there was just a lot of buildup. When will the new guidelines be released? So I was not surprised by the sort of departure from the 2010 guidelines. But that said, I think delving into the substance of the guidelines, there is a lot to unpack there, especially for those in the healthcare industry. And I will say, Meg, this is perfect timing for this podcast, because not only have we in the antitrust bar had a chance to review the guidelines in depth, we've also had a chance to hear from the U.S. Department of Justice and the Federal Trade Commission as to their views about why they issued the new guidelines and what the guidelines mean in practice. So I can't wait to get into
wow. With you. Well, back to law school days, which is now like 25 years ago, taking antitrust was one of the most dense and hard of all classes, because there's a lot of concepts there. So we're not going to do Antitrust 101 here, but, that's just sort of talk very high level about, what, and these guidelines really focus on mergers. And I think while it doesn't just apply to healthcare, it seems like healthcare is a driver in perhaps why they felt a need to change some of the structure around this. So tell me a little bit about, what these guidelines are doing. And I have so many questions around, there's in our world of hospice regulatory stuff, we focus a lot on rulemaking, right? What does the statute say? What authority does the agency have in terms of rulemaking, and then the rulemaking process, which has, notice and comment and all of this. And so this is not a law change, right? This is just guidelines. But what does that mean?
Right.
So the Sherman Act and all that stuff has stayed the same, right?
The Sherman Act isn't going anywhere. Has been in place since 1890, and our friend, the Sherman Act, is not actually, while it's important and it can guide merger review, Section 1 of the Sherman Act in particular, Section 1 of the Sherman Act and Section 7 of the Clayton Act are really the two statutes that could prohibit what the antitrust enforcers believe to be an illegal merger or acquisition or even a joint venture. And so that's the core sort of statutory regime with which we're dealing. And then as part of Section 7 and Section 1, and the analysis under Section 7 of the Clayton Act and Section 1 of the Sherman Act is the same, according to prior judicial precedent. This analysis of whether a merger violates Section 7 of the Clayton Act is driven by these merger guidelines, as well as judicial precedent. And so obviously the merger guidelines haven't been in place forever. But, since the 1960s or so, various iterations of the merger guidelines have been released by DOJ and the Federal Trade Commission, the two antitrust enforcers who are responsible for evaluating whether a merger may violate the law. These various iterations of the merger guidelines are what we're talking about today. And essentially, they are the agency's roadmap for analyzing whether a merger, acquisition, or joint venture could, number one, substantially lessen competition, or number two, tend to create a monopoly. And that's really what the crux of Section 7 of the Clayton Act says. But of course, the merger guidelines are full of a whole lot of detail and analysis that isn't present in the statute.
So maybe just to pause there for a second. So the notice comment structure we have for when we deal with CMS, like, do we as a public have an opportunity to comment on these and have, like, the government has to take that into account and respond to comments? Or it sounds like all of this stuff is fought in court. And you talk about judicial precedent, which obviously in hospice regulatory stuff, there could be, but not, there just isn't as much because we have a lot of administrative procedure. But it sounds like here, it's a very different kind of structure. They can put out these guidelines and say, this is how we're going to do things. And we as an industry don't really have a lot to say.
Yes, exactly. So the agencies are seeking comments on the proposed draft of the merger guidelines.
Okay.
And through September 18th, 2023, the public has a chance to submit comments via regulations.gov. That said, the merger guidelines are not considered binding on courts, so courts don't have to follow them. Although courts have and can, use them as persuasive evidence. And many courts, most courts, have accepted the 2010 version of the merger guidelines and cite to them in their decisions. So they are quite persuasive, it seems, to courts. We'll see if this latest iteration remains in its current form or whether the agencies take into account probably a good number of comments that are going to be submitted and have been submitted. And we'll just have to wait and see sort of what the final merger guidelines look like. Sort of the ultimate question is whether courts, decide to use them as persuasive evidence or whether they continue to rely on the 2010 guidelines because that's what they've been using previously.
So what generated this? So you have 2010, now we're in 2023. What's changed? What made them? Is this just a reflection of the current administration solely, or has there been a drumbeat for a while over the last 13 years?
Well, that's a great question. So taking that 50,000 foot view level, since the Biden administration issued an executive order on promoting competition in the American economy in the summer of 2021, this drumbeat has really been building by the Biden administration to review the guidelines and determine, whether there's sort of a better way to ensure that they achieve their goal, which is to reduce or prevent further consolidation in a variety of industries, including in healthcare. So the Biden administration and their review of these guidelines is really a way to make good on their promise to increase scrutiny of mergers and acquisitions that might be lessening competition and harming consumers or the competitive process in general.
And we'll be posting a link to the article you wrote, Wendy, on this in the podcast notes so people can read that. But in terms of healthcare, what kinds of things were they citing to that was of concern to them? I mean, we have a lot of payers who are now becoming providers and it seemed like perhaps there was concerns about how big some of these companies are becoming and maybe that they're doing so many things across the continuum, or was that not part of it?
Oh, no, absolutely. You're right, Meg. That was definitely a part of their thinking. I mean, prior to the Biden administration, other administrations have challenged mergers and acquisitions in the healthcare industry. It's just that the Biden administration really, put its foot down and said, hey, we view consolidation in a variety of industries, including in healthcare, as problematic, and we're going to take these extra steps, which included the executive order and then telling DOJ and the FTC to go forth and, use all of the available tools that they have to step up scrutiny in a variety of industries with respect to mergers and acquisitions. So, the Biden administration, even prior to the merger guidelines being issued, hasn't shied away from bringing challenges to major healthcare and pharmaceutical deals that they view as anti-competitive. They have faced some uphill battles recently with respect to, in particular, their challenge to what are called vertical transactions. So transactions where you've got, a supplier who's acquiring a manufacturer or someone at a different level of the supply chain where the acquisition's occurring. And in particular, DOJ challenged United Health Group's acquisition of Change Healthcare, which is now part of Optum. That was challenged by DOJ in court. DOJ argued that combination, which was a vertical transaction, would give United Health Group access to certain trade secrets and competitively sensitive information from its competitors in the insurance industry that it could use to bolster its health plan arm, even though, Change was not sort of in that same space. So ultimately, the court decided that this transaction could proceed, that it did not violate Section 7 of the Clayton Act. And there was a condition to that. But in any event, that challenge by DOJ within the healthcare space was not successful. And, part of that might be because the 2010 merger guidelines that it had been operating under and that the court was reviewing the deal under didn't really speak to the issues that DOJ was trying to assert would result in anti-competitive harm. And so these new merger guidelines, might help DOJ in the future when it tries to bring these more novel challenges to transactions that are occurring in the healthcare industry that are both maybe horizontal, but also vertical in nature. And so we'll just have to see. I know we've seen in the home healthcare sector recently a good number of large transactions where it's been publicly reported that DOJ or the FTC is reviewing the transaction. And one of those is Amedisys. And, we read in an SEC filing that was recently released that there was a second request for information that was issued in the transaction involving Amedisys. So we'll just have to see, if that one goes through or if it gets challenged in court. But we do know that DOJ is certainly is taking a closer look at these types of transactions that may not present horizontal overlap, sort of the traditional theory of antitrust harm, but present other issues that are not traditional under antitrust law, but that are being kind of discussed in these new merger guidelines.
In terms of, as an antitrust lawyer, which I'm always so grateful when I can call you, because this is such a nuanced area, and when you're advising a client, it could be challenged. And then do you sort of prepare your thinking about how you would defend that? Or is there a lot of stuff you do on the front end in terms of structuring and proactively sort of addressing these things? Like, how does this actually work? So, we're working on a transaction and, we're concerned it might get, reviewed. Like, how do you do your job? Like, what's involved in that? And how does that going to change in light of this?
Our recommendation to clients is to be proactive and to help us help them by allowing us to do an analysis of whether a proposed acquisition or merger or joint venture presents any possible anti-competitive harm under the merger guidelines. So we take a look at the merger guidelines, we take a look at the facts of the transaction, what is the rationale for the transaction, and we look at the various potential markets involved to determine if DOJ or the FTC or a state attorney general might be interested in, investigating the transaction further. And so we kind of come up with an initial gut reaction, and then, depending on the client's desire and or appetite, we could do further analysis. We can hire an economist to do some upfront work because both agencies, DOJ and the FTC, have their own economists on staff. So we always, like to be as prepared as possible if we think there's a significant, substantial possibility that one or more of the agencies or state AGs might open an investigation into a proposed transaction. So another thing that we stress to clients is good document hygiene with respect to when they're considering a transaction. So that essentially means, make sure that the business folks are articulating, what are the rationale for the deal? Why is this not only good for the company, but good for patients and the community? And, to really kind of set that forth in documents early on is helpful because a lot of times, folks maybe don't think about putting that in a presentation to the board. But at the end of the day, that is their reason for doing the deal is to, for example, increase quality of care or increase access to services or increase innovation or technological capability. And those points are really helpful if, they're articulated early on and consistently by organizations considering a proposed transaction.
That's really helpful. And I think, one thing, and you and I have worked on a number of projects where we've done sort of just that at the very beginning, where people are exploring stuff, bringing you in to have some conversations around antitrust issues. Because I think I don't want our listeners to think, well, I'm not a giant company, so I don't need to worry about antitrust, right? So I think everyone needs to be aware of that. And, you talked about how you define the market, right? It doesn't need to be national. It can be, very localized and, geographic. And so that's important. And I think something you said too is joint ventures, and we're doing more and more of those and working on establishing clinically integrated networks. And clinically integrated networks are somewhat a function of antitrust law, right? And so a number of the things that you're talking about need to go into that analysis if you're trying to create a clinically integrated network, which, as I'm thinking about this, we need to do a podcast on clinically integrated networks and how you think that might change in light of these new guidelines as well. But that's another podcast. We could do 14 hours of antitrust stuff. But
I personally would love that, Meg. So yes, let's do that. I don't know if your listeners would enjoy that, but I would love it.
Well, I love learning from you, and but you were going to say something.
Well, one thing in addition to what I just said about your question, these smaller transactions, even though, they might not be what are called reportable transactions to the Department of Justice or Federal Trade Commission under the Hart-Scott-Rodino Act. So that's a whole separate podcast probably, but they still might catch the eye of DOJ, FTC, or state AG. Number one, because, there might be media reports about a transaction, or number two, a competitor or a third party might decide to complain to DOJ, the FTC, or state AG about a transaction, even though it's a smaller transaction. And I actually helped to litigate a case that was not reportable under the Hart-Scott-Rodino Act. It was a smaller transaction involving an acquisition by St. Luke's of Salzer Medical Group. And that transaction ended up being investigated by both the Federal Trade Commission and Idaho State Attorney General, and then ultimately went on to be litigated up to the Ninth Circuit. Wow. And the court ordered that transaction be unwound. It was a consummated transaction. So just another note to your listeners that smaller transactions are on the FTC and DOJ's radar. And in particular, these new guidelines talk about the need to review what are called serial acquisitions. So most likely by a private equity firm, but also could be by a larger company that engages in a sequence of transactions that the agencies may view as kind of accumulating, some sort of anti-competitive harm. So there's a guideline in these draft merger guidelines that explicitly discusses that a series of smaller transactions can be reviewed. And, of course, the agencies have always had that authority to review transactions after they close, but it just underscores that they are planning on reviewing a series of smaller acquisitions if they view it as anti-competitive in some manner.
And maybe last thing here, because I was just thinking of Hardcore History, which is a podcast that goes on for hours about like things, and we'll do our hardcore antitrust here. But I guess last thing maybe for today's podcast was about, there was some litigation around anti-competitive things related to staffing agencies or how agencies might be, limiting people's ability to move out or whatever. And maybe you can talk briefly about that, because that came up a bit in the merger guidelines too, is how does this impact staffing, right? Or employees' ability to freely get a new job or whatever.
Another great point. I mean, again, this scrutiny by the Biden administration on the effects of consolidation as to the labor market is something that we're seeing being borne out in these merger guidelines. So not only is DOJ criminally prosecuting alleged no-poach and wage fixing agreements that are and it has been focused on the healthcare industry, in particular, the staffing agencies, as you mentioned, and alleged agreements not to solicit, not to poach, and then to fix wages or suppress wages for these temporary staff workers in the healthcare industry. In addition to that, the new merger guidelines have a guideline that explicitly discusses, the fact that the agencies will not only request labor market information as part of a merger investigation, can do that, will do that, but also could, challenge a merger that they view as harming a relevant labor market. And so all of this, suggests that the Biden administration continues to be focused on its goal of, ensuring that the workers' mobility is not somehow limited and that their wages aren't suppressed. And it's trying to get at this issue in a number of ways, including through the new merger guidelines. So a proposed healthcare merger, if it's reviewed by the DOJ or the FTC, you can bet that, one of the questions that they will ask is, hey, send us, information about your employees, the wages they're earning, are there any documents that discuss the impact of the transaction on, your employees? And in addition, this is a particular interest to the enforcers in the healthcare industry because of the industry's specialized skills and training and licensure. So certainly the Biden administration is laser focused on labor market issues in the healthcare industry.
Yeah. Oh, my goodness. There's so much here. And I think maybe my reflection and hearing, all of your insights here is, I think being able to, an issue spot isn't like, oh, I'm the CEO, I need to have a deep understanding of antitrust, but I think you need to be sensitive to this from the beginning. And it doesn't really matter how big or small you are, because as you said, states can get active in this area. And as we know, there's 50 different, approaches maybe to how aggressive people are going to be. So I think it's worth putting on your radar screen, as you begin thinking about this, and you use the phrase document hygiene, but I mean, I think that, very helpful to get some training on what that means. And because trying to, after the fact, demonstrate your intent as opposed to have contemporaneous documentation about your intent, I mean, you'd rather start with the contemporaneous documentation of intent. Like when we started talking about this 2 years ago, this is why we were doing it, right? Instead of like later trying to say, well, no, of course we were trying to do those things. And so.
Absolutely. And I think another takeaway is just that, if your transaction is reviewed for some reason by a state AG or DOJ or the FTC, you're going to go through a longer investigation period. It is going to be more expensive and, more burdensome, generally speaking, for the parties involved. Unfortunately, the new merger guidelines might actually have, and they're intended to have a deterrent effect on parties looking to merge. The underlying kind of tenor of these guidelines is that the Biden administration seems to prefer organic growth, right? So build versus buy. But this is going to potentially hurt smaller companies, smaller organizations who, for one reason or another, feel that they can only achieve certain efficiencies or benefits, pro-competitive benefits from a merger versus, having to go out and raise capital to build or to, organically grow or expand in the healthcare industry. So, my concern is that it will have a deterrent effect on the wrong types of organizations and companies, the smaller ones, and it won't necessarily affect the behemoths as much because they have the resources to go out and defend a litigated merger challenge. So that's one additional thought.
Yeah, and I think at least in the hospice space right now, among smaller providers, is coming together more to create efficiencies, which is something that is okay, right, to do. But because a lot of those combinations are, I just can't get the scale to reduce my overhead and become more cost effective in my delivery of care, which, is a very valid point. Anyway, I think that it's not that people shouldn't be thinking about doing those kinds of mergers or whatnot, but I think you got to get sensitive to these issues and make sure you're thinking about them from the get-go. So, but anyway, well, fun topic.
And absolutely agree on all counts with you. The earlier folks can start thinking about these issues, the more guidance we can give and hopefully help reduce the risk that, a transaction is investigated, let alone challenged, and
alone unraveled and
unwound. Unscrambling the eggs is not fun.
Yeah. Ugh, that sounds like a headache. But, well, thank you so much. This has been really, really interesting. I think great for our listeners. So thank you for taking the time. And then again, we'll post your article too that's a bit more detailed in some of these areas. And then obviously folks can feel free to reach out to. So my guess is this won't be the last article, Wendy, you'll write either on this topic. So more to come.
There is definitely more to come once these are finalized. We will certainly, have a follow-up article. And then, if there are breaking developments in between, absolutely, please continue to watch our blog posts.
Yeah, for the breaking antitrust news. Yes. Right. We all live in our little worlds of intrigue, right?
Exactly. Yeah. The antitrust nerd bubble.
Yeah, exactly.
Where I reside. So.
Yeah.
Well, thank you so much, Meg, for having me. I really appreciate it.
Yeah. Thank you.
We'll look forward to talking further at some point in the future.
Great. Well, that's it for today's episode of Hospice Insights, The Law and Beyond. Thank you for joining the conversation. To subscribe to our podcast, visit our website at hushblackwell.com or sign up wherever you get your podcasts. Until next time, may the wind be at your back.